All right, welcome to The Explainer. Today, we're diving into a fascinating legal fight between a homeowner and his HOA, a real David versus Goliath story. And what's wild is that the entire case, all of it, came down to the meaning of just two little words in the law. So let's just start with the big question at the center of all this, something you've probably wondered yourself. Can your HOA just flat out deny you access to its own records? Well, the answer is it's complicated. And that journey is exactly what we're going to unpack today. So our story kicks off with a homeowner in Arizona, a guy named William M. Brown. He's part of the Terravita Country Club, and he does something pretty standard. He asks to see some of the association's records. A totally normal, straightforward request. But what should have been simple, well, it wasn't. Mr. Brown sends his request on February 6th, and just 8 days later, bam, the HOA denies it. By April, things had escalated so much that he felt he had no other option but to take it to the next level and file for a formal hearing. Now, here's where it gets really interesting. The HOA didn't just say no. It was the reason they gave for the denial that sets this whole case apart and makes it so important for every homeowner out there. This wasn't about missing files of privacy. Nope, this was a very specific and kind of shocking legal argument. So get this. In an email, Terravita said, and I'm quoting here, "The records that you request are part of the pending criminal litigation against you." They basically argued that because Mr. Brown was dealing with a completely separate legal issue, they could lock him out of the HOA's records. A very bold move. And that brings us right to the heart of this whole thing. The lawyers, the hearing, the entire fight, it all boiled down to the legal meaning of just two words: pending litigation. What do those words actually mean when it comes to HOA law? Okay, so this whole mess lands in front of a judge, and now both sides have to argue their case based on what the law actually says. So let's take a look at the statute ourselves, and you'll see how two groups can look at the exact same words and see two completely different things. First up, you've got the general rule in Arizona. It's pretty clear-cut. It says that HOA records shall be made reasonably available to any member. It even puts a clock on it. The HOA has 10 business days to get it done. This was the whole basis for Mr. Brown's request in the first place. But of course, like a lot of laws, there's a catch. There are exceptions, and the HOA pointed right to the one that lets them withhold records related to, you guessed it, pending litigation. This was their shield. This was the loophole they thought gave them the power to say no. And this is where we get two totally opposite takes. Mr. Brown's side argued that this exception only counts if the HOA itself is actually part of the lawsuit, and in his separate criminal case, they weren't. But Terravita, they went for a much, much broader definition. They claimed pending litigation could mean literally any lawsuit involving the homeowner, even if the HOA had absolutely nothing to do with it. So that's the big question, right? Who's right? With two completely different readings of the very same law, it all came down to an administrative law judge to make the final call. And let me tell you, the judge's ruling was not wishy-washy. It was incredibly clear. She didn't just pick a winner. She laid out the legal logic behind her decision. And in doing so, she set a huge precedent for how every HOA in the state should be thinking about this. The judge started with this really fundamental idea in law. She said that any law has to be given a sensible construction that avoids absurd results. Basically, whatever you decide the law means, it has to actually make sense in the real world. And this is where she completely dismantled the HOA's argument. The judge pointed out that if the HOA's broad interpretation was right, it would lead to an absurd result. Think about it. An HOA could deny you records just because you were going through a divorce or had a small claims dispute with your neighbor. It would create this giant, ridiculous loophole that makes no sense. So the final decision was crystal clear. The judge sided with the homeowner. She ruled that the pending litigation exception is narrow. It can only be used to keep records secret when the HOA itself is an actual party in that lawsuit. Period. And here it is, right from the final order. The judge declared Mr. Brown to be the prevailing party. A complete and total win. So the big question now is, what does this win really mean for the rest of us? So why did we just walk through this one specific case? Because the result has huge implications for pretty much anyone who lives under an HOA. This isn't just one person's story. It's a really important lesson in knowing your rights. And hey, it wasn't just a moral victory. There were tangible consequences for the HOA getting the law wrong. The judge ordered them to pay back Mr. Brown's $500 filing fee. It might not be a huge amount of money, but it's a clear signal that the HOA messed up. So, what's the bottom line here for you? First, remember you have a fundamental right to see most of your HOA's records. And they're on the clock. They've usually got 10 business days to get back to you. Now, yes, exceptions exist, but this case proves they have to be interpreted reasonably. Your HOA can't just use some unrelated lawsuit as a blanket excuse. And maybe the most important thing, this shows you have the power to fight back if you think a denial is just plain wrong. So, we'll leave you with this thought. This entire battle was won because a judge looked for the plain meaning and sensible interpretation of a law. It kind of makes you wonder, what rules in your own community are being enforced based on an interpretation that maybe isn't so plain or so sensible after all? Definitely something worth thinking about.